Okay, well, it's your last one. Okay, we're number 4. And it's the best one. We're talking about drugs. Okay? I'm going to talk about the drug statute in workers' comp. Dana's going to talk about weed in the workplace, or otherwise known as marijuana. Now, the fact pattern that we had today brings some interesting issues. So, there are 2 things that I want you to remember in my short talk. One is rebuttable presumption, and the other one is reasonable or approximate cause. So rebuttable presumption, approximate cause. I'm going to talk about rebuttable presumption first, because that's the big kahuna in workers' comp. If you have somebody who tested positive for drugs, if you get reasonable rebuttable presumption, you don't have to do much. The burden is on the injured worker to establish that their injury did not occur as a result of the drugs. You enjoy a presumption that this injury occurred because they were impaired, either marijuana, cocaine, opiates, okay? How do you get rebuttable presumption? Some real basic things. First, you have to have a drug policy. You have to train on the drug policy. You need to post. The Bureau of Workers' Comp sends out these little things that says if you test positive for drugs or alcohol, it could affect your workers' comp claim. So that has to be posted. You have to have it in your handbook, a drug and alcohol policy in the handbook. This is the biggest issue, though, that employers face. You have to have reasonable suspicion to do the drug test in the first place. Well, what do we have in our fact pattern today that is reasonable suspicion? So we have slurred speech. One of the witnesses talked about slurred speech. Acting strange, not in a good way in the meeting, the safety meeting in the morning. What if you didn't have that? You got the ex-girlfriend saying that they smoked a blunt at lunch. But what if you didn't know that before you did the drug test? Good question, huh? Yeah. So, how about the accident itself? Looks like they were racing, engaging in horseplay. I think that's reasonable suspicion. That's kind of unusual. So, you know, those are what I call indicia of reasonable suspicion. You want to have reasonable suspicion to do the drug test. Once you have that, you do the drug test, you get a report from the doctor, you meet all those requirements, you enjoy rebuttable presumption. So the claimant then has to establish that their injury did not occur as a result of the impairment. And that's tough for the claimant. Okay, let's talk about proximate cause. What if you didn't have any of that? What if somebody's just driving a forklift and, I don't know, they hook their forks onto a pole and it kind of jerks them? Not really maybe that unusual, but let's just assume that they were doing everything right. Do you do a drug test? Why? Why do you do a drug test? Because you always do a drug test? Okay. Mark, do you do a drug test?
Well, I was going to ask about if you do random drug tests.
Yeah.
Does that cover what says you can't do?
No, you can do random drug tests. Yeah. What OSHA is concerned about, and I don't know if Tybo talked about it, what OSHA is concerned about when they say they don't like automatic post-accident drug tests, they think that it prevents people from reporting injuries. So if you're doing carpal tunnel syndrome, why would you drug test somebody? If they have a bee sting, why do you drug test them? But I mean, I'm just saying, if there's a possibility that drugs and alcohol are involved, always do a drug test. And you can almost have, in any case, a possibility that the drugs and alcohol were involved. And this is being recorded, so I'm on the record.
Yeah, well, this, at least with what we've heard today, OSHA's ruling is now headed down a path of you have to have suspicion that the accident was caused by impairment before you can drug test. So I mean, it seems to be getting more liberal just on its own momentum.
It's sort of like a train got on the track and it's heading in that direction. But I've talked to the people at different area offices, and they say their main concern is you are not discriminating against certain people. So if you have a blanket post-accident drug test, you're not discriminating, they're not concerned about it, which is opposite of what they talked about in writing.
So if you have a blanket random drug test, even if you did it after an accident,
that's fine. So what do you do?
I like how you think as usual.
Yeah, I know. And I would, I don't want to get off target, but this whole thing about OSHA and the post-accident drug testing, it's commentary to one of their rules. It's not even a regulation.
Everyone straight. Major fluids, large things, Wolverine is there. Hey, I'm Scott Free. You got Scarlet Gray is the U.S. employer that uses Wolverine as their temporary employee. You got Jim Beam who's employed by Scarlet Gray. In Ohio, there is an immunity. Both for employers and employees for injuries occurring in one facility. You can't get sued for damage. This injury is pretty much the foundation of what this conversation
All right, medical marijuana. Has anybody had to deal with this yet in your workplace? Nobody? Nobody's had an employee that turned up positive for marijuana and they said, I got a card for that. No? Okay.
We had a medical person tell us that we only had a month before we had to change our drug policies.
Okay. I don't know who that medical person is, but
We didn't take legal advice.
yeah, don't take legal advice from medical people. Bad idea. Okay, medical marijuana is legal in Ohio, but it's not quite here yet. Right now there is an advisory committee that is developing rules. They haven't formalized any of the rules yet, except mostly for the cultivators, and those will be finalized within the next month. But they're coming, and the medical marijuana is coming. So as employers, what do you do about it? In our presentation up here, you had Joe and Heather so helpfully said, yeah, Joe and I smoked a joint out in the car during lunch, but it's okay because we got cards. As an employer, do you have any rights? Can you terminate these people for the use of medical marijuana? What do you think? You say yes? If you have a policy, what policy? Your drug-free policy? Okay. Any other thoughts? I'm seeing heads nodding yes. They smoked it? Oh, you're so smart. Yeah. Okay, you actually have two problems here. One of them is that, yes, you can terminate an employee for use of medical marijuana. Even if they have a valid prescription for it and they get it from a valid dispensary, you can still fire them if it's a violation of your drug-free work policy. And I've been telling all of my employers that add the language to your policy. Any and all drugs, comma, including medical marijuana, comma. Add it. Because you don't want to have any questions later about whether or not they knew that medical marijuana was covered by the policy. Under the statute, it's covered. And let your employees know that you will not be allowing it either. Okay, so add it to your policies. Yes, smoking is a problem, and I'm glad that you brought that up. Smoking is a big problem because even under the legalized form in Ohio, you would never be able to smoke it. Smoking is specifically prohibited under the statute. There are other forms you can take it in, such as vaping, which is an electronic cigarette where you inhale the vaporized oil. You can have it in a tincture, which is the oil of the marijuana suspended in an alcohol form, and it comes in a little bottle with a stopper, and you can put it into your cereal or your tea or whatever you're drinking. You can have edibles. You can eat it. But the law also states that the edibles cannot be attractive to children. So you're not going to see marijuana lollipops, probably, or marijuana brownies, but maybe marijuana broccoli. You can also have the plant form, but you can't smoke it. I'm not sure what you're going to do with the plant form, but you can have it. Maybe you can make a tea with it. Somebody in another group suggested making your own brownies, which I think is a great use for the plant-based material. So those are the forms. You would never be able to smoke it. You're never going to have an employee smoking a joint on the premises. And we're running very short on time. In your materials, I've given you a list of the conditions that right now they're looking at for approved usage of medical marijuana. Typically, they're going to be conditions that have chronic pain or chronic nausea, involuntary movements like Parkinson's and Tourette's, or mental health conditions that have been found to be improved by the use of marijuana. And patients who use the marijuana will have a card. They'll have to purchase that card. Right now they're proposing about $50 a year for a medical marijuana card, and that's on top of the cost to purchase the marijuana. But as employers, you have rights. Like I said, you can terminate them. You do not have to accommodate any use of medical marijuana for your employees, but I would caution you to make that explicit in your policies. There is also no private right of action if somebody is terminated for medical marijuana, meaning they can't haul you into court and say, you violated my rights by terminating me. They can still do that for age, gender, race, national origin kinds of claims, but they can't do it for medical marijuana. So there's a whole statute within the law that talks about the rights of the employers. And if you haven't seen it yet, I can give you the section number. It's a great section for employers. So you can refuse to hire them as well if they don't pass a pre-employment drug screen. You can discipline them under your progressive discipline policies. You can terminate them or you can discharge them. But let's talk about some other laws and the interplay with those. Workers' compensation. You have somebody who's injured on the job site, and their workers' comp doc prescribes medical marijuana for their condition. As a self-insured employer, do you have to pay for it? Or does the Bureau have to pay for it? You're making a face at me. You don't know. That's a good question, isn't it? The answer is no. The law states that you don't have to pay for it. The Bureau is not going to pay for it. They can get the prescription. They can pay for it themselves, but you don't have to do it. What about unemployment? When they're terminated for the use, do they get unemployment benefits? No? You're shaking your head no? No? Answer is no. Oh, you think yes? You're wrong. But you can still have a cookie. No, the unemployment statute has been amended to state that termination for use of medical marijuana is just cause, meaning that there is no benefits. What about the ADA? Do you have to accommodate the usage under the ADA if they have a serious health condition and their doctor wants to prescribe medical marijuana? And I'm talking cancer. Somebody has cancer. You say no, and you're making a face. Mm-mm.
Because it's federal, there's no federal obligation to accommodate marijuana.
You're absolutely right. The ADA and the FMLA are both federal laws. And under federal law, marijuana is still a Schedule I drug, meaning that it is completely illegal. So you do not have to accommodate the use under either the ADA or the FMLA. Good to know. Okay, I'm sorry I didn't get questions, but if you have questions, we'll be up at the panel in a little bit.